Morning, Judge.
Morning. All right. Been given a link in chat. Is that to the what's to be heard today?
I believe that is to defendants' exhibits.
Okay.
And I had previously sent our documents to Miss Riley. Kirk, for some reason, I was getting a kickback. Every now and then I'll get a unable to deliver on yours. I remember that happened a while back with Marjorie as well. But it's all I sent was the motion and the reply.
Okay, I have not seen it, but obviously I have it from other reasons.
I'm realizing that if I sit up too much, you lose the top of my head in the wall. Got that little shine, but I promise it's there. I'm not a cat.
All right. Give me a moment.
Judge, I believe I forwarded that those links or that paperwork to you, the motions from Mr. Moore on the 13th. If not, I can send it again.
Please send them again because
I just sent them, Judge.
And Judge, I'll tell you, we're experiencing some pretty substantial storms right now. Hopefully that doesn't affect our power or servers. But in the event that I'm kicked off because of the inclement weather, I will get back on as quickly as possible.
okay. It's trying to download things right now, it says. All right. Well, it says I'm downloading just some of the documents. It says 4 days left.
That may be, I think there were some videos that,
No, yeah, I didn't click those. Okay,
I was having trouble.
5 minutes, so it's 14 minutes. Let's see.
We sent them in paper too, Your Honor, if, obviously not the videos.
Okay, where did you send them?
I assume we sent them to the clerk, but I honestly have no idea. I just, I had staff do that.
Okay, well, the clerk is in Pearsall and the court administrator is in Jordanton and I'm in Floresville, so.
That would be a problem.
Seven minutes left. Okay. And this is, Mr. Swaney, this was your link. I'm just trying to. Let me cancel this again. I'm going to download just the motion and not all of the attachments. Or any of the attachments.
I was planning to share screen what I would refer to, Your Honor.
Okay, and what is it that I'm downloading? Second motion to compel?
That is one of the things left on the docket, Your Honor, the second motion to compel. The motion to compel the depositions from defendant back against Invoke and JW Power, we submitted agreed orders on. So what's left on the docket is JW Power's motion to compel and for sanctions back against Frio, Frio's motion to compel, second motion to compel RFPs on JW Power.
And is there a response on this second motion to compel?
Yes,
There is, Judge.
Right. If someone would send me a link to that in chat.
I will send that, Your Honor.
Love to get a new computer that works. I just went and tried to check my email, but that's too many apps open. If I have more than about 2 apps open, everything crashes. And I was able to not have to reboot my computer. But I've got the app Chrome open to download the link and then Zoom open. And you may know from Wednesday, I was having plumbing adventures. I'm at the house this morning and the plumber just pulled up. So while this is downloading, it's still less than halfway. I'm going to go and talk to the plumber for a minute and I will be back as quick as I can.
understand all too well, Your Honor.
Thank you, Judge.
No.
I'm asking you about
All right, give me a moment to read the gist of the motion and the response.
And Judge, just to be clear, we're taking up our motion to compel first, correct? Since it was first filed. The motion to compel the chief appraiser's deposition.
Okay, I have not seen that. All I have is the motion to compel the documents from the third party.
Those were the motions and the motion that Ms. Riley emailed to you. We filed that a couple weeks ago.
Okay, well, I did ask people to, whatever I need to look at, to post that to me in chat. I had to close down my mail server because I can't have more than 2 things open at once. And if I have Acrobat open and Zoom open, that's 2.
I see, Judge.
And
I misunderstood and I apologize.
they've been 2 weeks from having this computer replaced since about the 3rd week of March.
I can empathize, Your Honor.
I've just shared our motion to compel and our reply. I'm unsure if the link that you've downloaded was their response to our motion or if it was their motion to compel the second response to the second RFPs.
They're downloading.
And Judge, I'll tell you on their second motion to compel or motion to compel second responses, we've offered to enter into an agreed order subject to a protective order, which would dispose of the motion. I know I think yesterday, although I was tied up all day, they had some questions about whether we would be asserting privilege, specifically the work product privilege. And, Judge, I mean, we have terabytes of data we're going through. I can't say definitively whether we would submit a withholding statement and submit a privilege log for in-camera review by yourself. But again, we're willing to withdraw our objections and produce subject to our rights under the rules of civil procedure and evidence.
Let me make sure I have everything first. And is there a response from the appraisal district on the motion to compel answers to interrogatory questions? You're muted, Mr. Swinney.
The motion is ours. The JW Power has responded, and we have not responded to the response.
Okay, no, I'm talking about the motion to compel answers to interrogatory or to deposition questions.
Yes, Your Honor, we have responded to that.
Send me a copy of that.
Yeah, just a second. It's kind of voluminous. Thought it was in the upload site. Maybe I'm wrong.
I think it's a 400 something pages long. It may be worth just pulling the motion out of that from the exhibits and just sending that so you can read it, Your Honor.
If you give me a moment, Your Honor, I'll make sure it is actually in that upload site. It is a pretty voluminous document.
If you could pull out just the motion and post that in chat, or just the response, rather.
Yeah, response. Yes, sir.
The brief.
That may take some doing, Your Honor, because I don't have it segregated. I can probably give you the Word version segregated. Would that be sufficient, Your Honor?
Well, if you could post Word versions in Zoom, yes. But
I know I can post it in the upload site.
all right, try that, and then I'll have to shut my Acrobat down because that's would be 3.
Your Honor, let me see if I may be able to do this pretty quickly. Let me see if I have that response downloaded on my computer, and I can pull out just the motion itself.
And good morning, Ms. Marcini. Haven't said hi.
Good morning, Judge. How are you today?
Very well.
Good. Good to see you again.
All right, there you go, Judge. I just submitted just the response pages, which were pages 1 through 17 of defendant's motion or response.
And I've uploaded them to the download site to you.
All right, let me look at this for a moment. Okay. So are the parties ready to proceed?
Yes, Your Honor.
And I believe Mr. Moore has said that his motion to compel was the first in time. Is there an agreement on that?
I believe that's correct, Your Honor. It was filed Monday of last week, I believe, if I recall correctly.
That was the reply. Our motion was filed on, I believe, April 2nd. Our response was our reply to their response was filed last Monday, or on Monday rather. Oh no, so I guess you're right. That may have been April 2nd. Either way, it was first up.
All right, go ahead, sir.
All right, let me. All right, Your Honor. Hopefully you can see my share screen.
Yes.
Your Honor, there are three basic issues in our motion to compel. The first is whether Mr. Swinney's instruction to the chief appraiser not to answer deposition questions violated the Texas Rules of Civil Procedure. Second, whether that instruction constituted an abuse of the discovery process. And then third, whether that abuse of the discovery process entitles us to sanctions. We believe, of course, the answer to all three of those is yes, and understand that Mr. Swinney will vehemently disagree. So just a little bit of background here. I know you've heard at least, I think, one motion related to this particular suit. But what we're talking about here is fundamentally whether an appraisal district can improperly appraise dealers' heavy equipment under section 23-1241 of the Texas Tax Code. This is a separate, independent, unique form of property. It was misclassified and taxes were collected from JW Power improperly for years. Despite the language of the statute, it wasn't until the Supreme Court stepped in and mandated that districts give the money back and do this right that the districts actually started to comply. We have filed, or taxpayers and owners of heavy equipment have filed hundreds of suits across the state. And that's referenced in, I believe, Mr. Swinney's response as well. I would hazard a guess that 95% of those have been resolved, that the districts have stepped up, said, you know what, we got it wrong. Texas Supreme Court said we got it wrong, and we're going to refund your money. I know for JW Power, we have outstanding, I believe, 12 cases, or sorry, not outstanding, but rather we had 12 cases with Mr. Swinney's firm on behalf of JW Power in various districts, including Frio. And quite a few of those have been resolved at this point. 3 settled. 1, the MSJ was granted for the taxpayer. 3, the MSJs were granted in favor of the districts, and those are on appeal. A couple of them, the MSJs were denied outright by the judge for both parties. And then 2, including Frio, there have been no MSJs filed. Now, this is a fact-intensive technical case where we have brought claims, JW Power has brought claims related to 2525C 2 and 3 of the tax code. 2525C 3 relates to whether the property that has been appraised is in the form and location described on the rolls. And there is a lot of dispute as to what both form and location mean, and whether in fact it is a legitimate avenue by which a taxpayer can attempt to correct the roll in a situation such as this. So related to those claims, you know, the district filed its general denial. Now they have also since I think on Monday or Tuesday filed some amended answers asserting res judicata as an affirmative defense. But in general, they've just denied outright that we are entitled to any relief. And this is, of course, after an ARB determined that our 2525C protests were not insufficient, but they denied that. They denied the protest, issued orders, we appealed. And the district has said, no, you're wrong. 2525C 2 and 3 does not apply. Now, related to those contentions, those legal contentions, as asserted by Mr. Swinney and his firm, we asked for the chief appraiser's deposition. Under the rules, we are entitled to discovery over a party's contentions. At the deposition, which I believe spanned a couple of hours, there were some questions that Mr. Swinney objected to and allowed the chief appraiser to answer, but there were a substantial number of questions that Mr. Swinney objected to and instructed not to answer. Questions related to basic facts, questions related to the factual bases for their legal contentions. And you know, Judge, in his response and in a couple of depositions since this particular deposition, which took place in January, Mr. Swinney has asserted, and others at his firm have asserted, that the only way we can get to legal contentions and the factual bases for those contentions is through contention interrogatories. Or I believe in a deposition that took place a couple of weeks ago, he said we could serve requests for admission as well. And I'll tell you, Judge, this was one of those situations where when I saw the argument made and when I heard that this was the position they were taking, it caused me to do a double take, because I mean, under the rules, it is very clear that discovery into legal contentions and factual bases are certainly permitted. And there's no limitation that I've ever heard of in case law, heard of in secondary sources, or certainly that's discussed in the rules that limits a party's ability to get that discovery. But it was one of those situations where when I saw that argument, I thought I could very well be wrong, and I was willing and ready to be wrong if necessary. But you'll notice in both their response, and I suspect when Mr. Swinney has an opportunity to speak, there's no case law that's current that allows only for contention interrogatories. There's nothing in the rules that says you can only serve contention interrogatories in order to get those factual bases for the legal contentions. But
did you notify the deposition of the chief appraiser as, was that person produced in request for someone to be deposed about the contentions of the appraisal district?
We noticed
or official representative.
We noticed the chief appraiser both. Sorry, Your Honor, I didn't mean to cut you off. We noticed him both as the chief appraiser, and we noticed a 199-2 rep, for which he was presented. So here I've just, you know, out of an abundance of caution, and it may be overly simplistic, I've just walked through the rules, and I did so in our motion. 192.3, the scope of discovery states a party may obtain discovery regarding any matter that is not privileged and is relevant to the subject matter of the pending action, whether it relates to the claim or defense of the party seeking discovery or the claim or defense of any other party. And it's notable in regards to having the chief appraiser deposed both individually in his capacity as chief appraiser and as a 199-2 rep. The chief appraiser is the executive of the appraisal district. He is the head of the appraisal district. So, and is the ultimate representative of Mr. Swinney's client. So I believe that he would have the capacity and ability, whether or not we noticed him individually in his capacity as chief appraiser or put a 199-2 rep as to specific topics, he would still be in a position to, and we would still have the right to ask questions about the contentions and the factual bases for that. And again, 192.3J states a party may obtain discovery, not contention interrogatories, not RFAs, discovery of any other party's legal contentions and the factual bases for those contentions. And this is notable because in his response, Mr. Swinney misinterprets and misrepresents what this section says. He says this section only applies to contention interrogatories, and that is simply not the case. Rule 192.1 lists out the permissible forms of discovery, which includes oral and written depositions. We have the option to to avail ourselves of all of those or none of those as we see fit. And of course, the rule has changed a little bit since January of 2021. We now have, or actually, I think this is current. The initial disclosures and expert disclosures rules have changed, but as of filing of this case, it was all may. We may obtain, we may request, we may serve. We're not required to serve, and we're not required to do it at any specific order. That is at our discretion, as long as we're serving it properly under the rules or conducting a deposition properly under the rules. And here, of course, 199.1A, a party may take the testimony of any person or entity by deposition on oral examination. This is an unfettered right as long as we comply with the rules. We are not required to do one before the other. We're not required to do one after the other. And just to reiterate, Your Honor, 192.3 is not limiting in its language or in the comments. On page 4 and 5 of their response, Mr. Cnty says, and I quote, the response, while contention interrogatories are acceptable, citing to Texas Rule Civil Procedure 192.3J, the response does not require more than a basic statement of those contentions and does not require marshaling of the evidence. That is a comment 5 to Rule 192. But again, that presupposes that 192.3J only allows for the discovery of legal contentions and their factual bases through contention interrogatories, which it does not. Again, the plain language is clear. And just whether that itself was clear, Brain versus Downey, which is a Supreme Court opinion from 1991, inquiry may be made during deposition into a party's contentions.
Okay, and did you ask for them to produce a witness who would testify as to contentions?
We asked for the chief appraiser to testify in his capacity as chief appraiser, as executive of the appraisal district, related to how property was appraised, which goes to the heart of these 2525C2 and 3 motions. We also asked for the 199.2 rep, and the chief appraiser was presented as the 199.2 rep, the representative for the district who could testify to factual or legal contentions and factual bases. Rule 192.3 also explicitly allows for, and the Supreme Court has upheld, that we can get discovery related to contentions, and it's not protected from discovery by privilege. Mr. Cnty is going to, I expect he'll come on later and he'll say, this is all the product of our analyses, our thought processes, therefore it's protected. However, legal contentions and the factual basis for those are not covered by privilege. He does not get to turn around and try to cover, say, we filed this general denial, we don't believe you're correct, but you don't get to know why. We don't have to tell you why we don't think you're correct. We are entitled to that discovery. We're entitled to the bases for which they believe we're wrong. Now, as for the objections and instructions themselves, because ultimately that's where we are. Mr. Cnty made multiple objections and instructed not to answer. An instruction not to answer in 199F is only allowed if it preserves a privilege, complies with the court order, in order to avoid abusive or misleading questions, or if under 199.5G the time is run up. Now here we are, of course, talking about option 1. Mr. Cnty has asserted that he needs to preserve the attorney-client privilege, and we're not entitled to basic discovery on the district's legal contentions and their factual basis. And 199.5F also requires that the attorney give a concise, non-argumentative, non-suggestive explanation when requested. I don't believe that Mr. Cnty did that in reviewing the deposition transcript, but that is a requirement. And then finally, and it's important to note here that it is Mr. Cnty and the district's burden to present sufficient evidence support both the objection and the instruction not to answer. It can't just be, we made these contentions, we opted, at the client's behest to do something or not do something, and that is somehow transforming basic discovery requests into seeking information that is privileged. And as I said, Your Honor, here we are, this is technical in that we are trying to figure out the metes and bounds of what 2525 C2 and 3 require and the things that are and are not allowed for an appraisal district to do in response to legislative mandate and opinions of the Texas Supreme Court. The policies and procedures related to the district's appraisal of this equipment is vital to the claims we're making. The district's knowledge and belief that the property has changed before or after EXLP, before or after an agreed judgment that was signed is vital to the claims, because we are talking about 2 specific years here, or I think it's 2 years in this one, that are prior to both of those, but after the enactment of this statute. And the reasons why districts chose to ignore and charge taxpayers, take taxpayer money and hold it, is certainly important to the claims we're making, the relevant sections of the statute, and ultimately what we may or may not be entitled to upon resolution of this case. Now, one other, Mr. Swinney spent, I think, about maybe 7 pages responding to the merits of the argument related to the objections and instruction not to answer. Of course, we've also asked for sanctions in this matter, which I'll tell you, Judge, in a decade of practice, I've not done. But when there's a consistent pattern of thwarting basic discovery, it's a hard thing not to need some sort of judicial intervention in a way that will curtail that abuse in the future. And we'll get to it in a little bit, but there is Mr. Swinney is going to point to his, 417 pages of exhibits in his response and say, if anybody has committed a pattern of discovery abuse, it's JW Power and their firm. But what he does is he conflates the proper assertion of objections with thwarting basic discovery. Under 192.3J, he has no ground to say we can't ask these questions at deposition. But he's going to say, well, they object and have required us to file motions to compel on discovery responses. And we'll get into that a little more. But one of the things that the reason why I raise it now is because he, in his response, suggests that somehow JW Power demanded that we enter into stipulations. But then I think a page later says, if they had just presented the facts and presented their legal argument, this would be resolved. Whether or not that's doublespeak, JW Power and this firm, we have tried to enter into stipulations from the get-go. We're not getting paid hourly. We are not being incentivized in any way to keep these things drawn out. We want resolution. This is, and I think Mr. Swinney would agree, is occupying a significant amount of bandwidth for both sides that in our opinion is incredibly unnecessary. But we tried to stipulate to these facts. We tried to stipulate to things that would take care of some of this. They refused, so we're now required to get the facts from the district related to our claims.
Okay, Mr. Swinney?
Thank you, Your Honor.
Well, Your Honor, before he goes, I mean, I'm not finished yet, Your
All right,
Honor.
I'm sorry. I thought you were.
No, I was pausing for dramatic effect, and I apologize for making it seem like I was finished. So now going more specifically to the questions and the objections, you see here, and these are in the exhibits. This is out of Exhibit 2 in our of our motion. This was pulled straight from the chief appraiser's deposition. We asked if property is assessed as business personal property under Chapter 22. And the property is assessed under as dealer's heavy equipment inventory under Chapter 3. That would be two different types of property, correct? To which Mr. Cnty objected form and instructed not to answer. Said you're calling for a legal conclusion. You're getting to the core contentions of the defendant in this litigation. Later on in the deposition, he objected, instructed not to respond when asked when we asked whether the chief appraiser had seen any compressor schedules from JW Power. Again, objected, calling for a legal conclusion, and sought attorney-client communications. We attempted to clarify. He stood on his objection. And then the third, we asked about why appraisal of the compressors changed from business personal property to dealer's heavy equipment. He objected and instructed the witness not to answer again, at which point we were forced to suspend the deposition. So there are three basic objections that supported in Mr. Cnty's mind the instruction not to answer. There's a legal conclusion objection. It goes to the core contentions of the defendant. There's the towing the line, and then of course the attorney-client privilege. Now, as far as legal conclusion, that is not an appropriate basis for instructing not to answer. Whether or not he believes that is legal conclusion, we are entitled to get the chief appraiser's answer, and then we can come to you and have that objection resolved and potentially have that deposition testimony struck. Instead, Mr. Cnty said, objection, legal conclusion, instructing not to answer. And again, the issue presented here is how these compressors were classified by the district. This is dependent on the application of the Texas tax code, which if we're asking questions about application of the Texas tax code, again, for which the chief appraiser is obligated to apply in the district, then we can't ask anything of the chief appraiser or the 199-2 rep, up to and including potentially, are you chief appraiser? He's only chief appraiser because of the application of the tax code. And if we can't cite two specific sections, say, how would you interpret this? Well, if that's a legal conclusion, then there again is no discovery as to how the chief appraiser applies the tax code and ultimately appraises and assesses taxes in his district. The second piece is the core contention objection. Again, we've kind of covered that already. Rule 192.3 gives us the right to seek information related to core contentions. If we're not allowed to get the factual basis for the legal contentions made by an opposing party, then we're not entitled to anything. Then Mr. Cnty can only assert a blanket. Sorry about that, Your Honor. A blanket objection to all discovery that relates to the suit. And it's important to note, like I said on Tuesday, they did file an amended pleading asserting an affirmative defense of res judicata. Of course, that is going to entitle us to discovery on that, up to and including deposition, where we are entitled to hear why the chief appraiser believes res judicata is an affirmative defense that denies us the ability.
Are you entitled to? Well, okay, go ahead.
No, that we're entitled to know the factual basis why he believes that, because this was presented on his behalf and at his presumable behest. And in the same way, he's entitled to ask our client why you believe this is in a different form and location than it is on the appraisal district rolls. We're entitled to say why you believe we are precluded from this. Now, he may say, I don't know. He may not have a complete answer, but we are entitled to ask. And you know, the other, we asked about discovery, what discovery was served, and whether the chief appraiser was had seen any schedules related to an agreed final judgment, and whether he felt he needed to see the same information in this suit, and why he believed he would need to see that same information in this suit to resolve the suit. You know, there are a couple of competing ideas here. The first being in regards to the settlement itself and information related to that settlement, including what he saw and what he based that on. That's discoverable under the rules. Second is the attorney-client privilege only applies to confidential communications. So there is a very I think solid argument that you've served discovery, so that is no longer a confidential communication. And certainly asking the fact of whether discovery was served is not a confidential communication. And two, that would apply to the pleadings as well. The moment you have put forth, this is my legal contention, it's not a confidential communication. Now, there may be some, it's the same as when you go into a deposition and say, have you talked to your attorney? That is a yes or no question. That does not implicate any confidential communications, and we're allowed to ask that question and get an answer on that question. Now, we're not allowed to go, what did you and your attorney talk about related to that? That would certainly be confidential communication that's covered by the privilege. In the same way here, discovery was served. We're entitled to a yes or no, up or down question on whether it was served. We're entitled to know why the chief appraiser in his capacity believed he needed that discovery. That is not implicating any confidential communications with his attorney. We're asking, what do you believe you need to know to resolve this case?
Okay,
Or,
are you asking him that as chief appraiser? Or are you asking him that as a designated corporate representative?
Your Honor, I think that's a distinction without a difference. I think as the chief executive of the appraisal district, the one who ultimately makes the decisions for the appraisal district, whether or not he is being presented as a 199-2 rep or the chief appraiser in his capacity as chief appraiser, then it's you know, apples to apples.
And so it's your position that you're not just asking this because you're hoping that the chief appraiser in Frio County won't be able to articulate in a succinct manner the legal reasons for the pleadings that have been filed?
No, Your Honor. I hope and trust that Mr. Gonzalez would be able to articulate fully. Where this is not a gotcha game. We just believe that if we can't agree on the basic facts here, which we've tried to do, we are entitled to the information through discovery.
You're entitled to it. Well, go ahead.
Now, Mr. Cnty attached some affidavits to his response, and from I believe Mr. Gonzalez and I can't recall who the other affidavit was from, and they stated that all of the discovery, all of the legal contentions were attorneys' work and not the district's. They're of course entitled to say that. I believe that's going to be a self-serving affidavit that's insufficient to serve as evidence of anything. But here's the other implication of that. So we're again talking about legal contentions and the factual bases. Mr. Cnty is now saying he is the only person who can testify to the factual bases of those legal contentions, but shouldn't have to because of the attorney-client privilege. Well, under Rule 308 of the Rules of Professional Conduct, that makes him a fact witness. And frankly, there's now a an argument to be made that, we need this testimony. We need the factual bases for the district's legal contentions. It goes to the essential facts of our claims under 2525 C2 and C3. Therefore, and we're not asking for it at this time, but there is a legitimate argument that we should be able to depose Mr. Swinney. And consequently, if he's the only person who can testify to these essential facts, there's probably an argument that he should be disqualified from representing the district. If he's the only one, or he and his firm are the ones creating these legal contentions, determining the factual bases for these contentions, then where else can we go? There's no other avenue by which JW Power can get this information.
Okay.
Now, the third one, and I'll try to wrap up here pretty quick, because I think we're pretty close to being done. The final thing is related to these policies and procedures. Again, we're talking about the multiple appraisal of dealers' heavy equipment inventory, and we're talking about the appraisal and taxation of property that was not in the former location that was on the rolls. And I am sure in the next probably couple of months, you're going to be hearing a lot more about that, because we will be filing our motions for summary judgments. But both of those items, the multiple appraisals and the form and location arguments, are related to the policies and procedures of the district for the years it issued. So we're certainly entitled to that. Why did the appraisal district change the classification? Why did the appraisal district not change the classification of the property despite a legislative mandate? And why did they refuse to apply the change backward for the years prior to 2017? Now, again, as I mentioned, I've talked a lot about what they did and didn't do, but ultimately it is Mr. Swinney's burden to present sufficient evidence that the attorney-client privilege attached in these instructions and objections were proper. They've not done that. They rely on a misinterpretation of the rules. They put words into the rules that are just not there. They ignore avenues of discovery that are available to JW Power. They take a position that all legal contentions are the product of the attorney, therefore it's all covered by privilege, which again would absolutely thwart an opposing party's ability to get discovery. We were entitled to take these depositions, to ask these questions. Now, and I don't know whether whether your honor wants to take up the issue of sanctions at this point or wait until Mr. Swinney responds, but we believe this is sanctionable conduct. The incidents that Mr. Swinney cites to in his response in an attempt to distract the court from our arguments are related to JW Power's assertion of proper objections and proper taking proper avenues. Whether or not he likes that, it doesn't change the fact that we are allowed to object to relevance. We are allowed to have our objections heard, but that is different than thwarting basic discovery as was engaged here.
All right, let's wait until Mr. Swinney has had a chance.
All right, Your Honor, then with that, I will pass and reserve the right to reply.
All right, Mr. Swinney, has the appraisal district, was the chief appraiser designated as the contentions test witness?
The chief appraiser was the designated representative of the appraisal district. And I'm glad to show you the notice of deposition, if you like, Your Honor. It did not, in so many words, say produce a witness on these contentions. It did list a number of items. Just a moment, Your Honor, I'll show you that. Here we go. This is the notice I think this isn't the most recent, but it's substantively the same, Your Honor. Again, it doesn't specifically say your contentions, but the appraisal classification of plaintiff's property made subject to this suit, 13 through 17. Any documents, protests filed by the plaintiff, there weren't any questions about that. Any documents, protests, or motions
Oh,
filed
but the deposition wasn't finished, so go ahead.
on behalf of the Frio Appraisal District. The Frio appraisal rolls 13 through 17. Any agreements or judgments relating to the plaintiff's heavy equipment, 13 through 17. Section 231241 of the tax code and the definition of dealer's heavy equipment inventory. Prepayment of taxes on heavy equipment dealers, and so on. Communications between employees and the plaintiff, and communications with outside appraisal firms. I think that's it. Let's see. Now here's several more. Communications between defendant and plaintiff, communications to any person or entity not previously identified. Defendant's treatment of section 231241 of the tax code, that's arguably in the ballpark. And the lawsuit, the 17 lawsuit. May I proceed, Your Honor?
Yes.
Your Honor, in the first place, we've submitted several exhibits with our motion, two being the affidavits of Mr. Gonzalez and Mr. Green, who is the attorney that handled the 17 suit, as well as other helpful admission or documents, I believe. For the limited purpose of this hearing, we request admission of those exhibits, Your Honor.
All right, Mr. Moore.
We object to both affidavits as self-serving. They are ipsy dixit, saying that we made these legal contentions in our pleadings, but we're all the product of the attorney. That goes to the heart of the contention, and we believe they're inadmissible because they do no more than serve as ipsy dixit related to the argument that Mr. Swinney is making.
Okay, I don't actually have a copy of them, so.
Hold on. They are part of the response, Your Honor. Just a moment, and I'll display them.
It would be better if you, well, if you could post them.
Okay, I can sure do that too. Well, let's see if I can post them individually. I'm not sure I can. I can post them in Word format, Your Honor.
That will not transfer to Zoom.
Okay.
Can you print the Word documents to PDF and then post that?
I believe that I can. It'll take a moment, Your Honor. Of course, those won't be signed.
While you're doing that, I want to go and check and see where we are with the plumbers. I'll be right.
Okay, thank you, Your Honor.
Okay, I'm back.
Your Honor, the affidavits, both of them as one document, are in the upload site now, Your Honor, the chat site, I should say.
All right, I'm downloading it. Okay, I've got them open. Go ahead.
Your Honor, the rules specifically allow affidavits submitted 7 days in advance or as sooner, more recently as the court allows, and I believe to be submitted as evidence of the privileged matter. It's Rule 193.4 that specifically allows that. And we can have the deponents here to actually testify if need be. But you see, Mr. May I share screen, Your Honor? Would that be?
Yes.
See, Mr. Gonzalez testifies that in cause 17, so on, JW Power versus Frio, and not this cause, Mr. Green, Leonard Green, and law office of Peter William Lowe represented the defendant. All decisions regarding discovery, if any, or any other matters on conducting that litigation were made by counsel. The district counsel advised me regarding settlement. All information I have on the conduct of the case was related to me by Mr. Green or his office. In the above captioned case, the Frio CAD, represented by Loswini and James, I have conferred with the district's counsel regarding all aspects of the case of which I have awareness. The legal theories, discovery, and conduct of this case were developed by the district's counsel and related to me by them. We're not trying to prohibit factual disclosure, Your Honor. Perfectly willing to disclose facts. We're perfectly willing to disclose contentions. It is just not the subject of a lay witness's testimony. When all those legal contentions were developed by counsel, all the handling of the case was developed by counsel. The service of discovery was sent by counsel, not by the actual party. Mr. Green, who was the attorney in the prior case, identifies himself, said he represented the appraisal district in that case and in many similar cases, as well as many similar cases for other districts. Says it was his practice to develop the trial strategies, including discovery decisions. Discussions were also direct communication between me as attorney and my client concerning the litigation, and I considered them confidential. It was and is my habit to discuss major issues with the client and make recommendations regarding the same. All major decisions, including those discussed in this affidavit, were made in the consultation with the client.
Can I respond, Your Honor?
In a moment.
Okay.
Any decision or action thereon to send discovery or not send discovery in those cases was based on our discussions concerning general trial strategy and all the pending dealer equipment litigation. And upon my recommendation, I advised the Frio CAD regarding the pros and cons of compromising and settling the case in consultation with client. I discussed options and made recommendations to the Frio County Appraisal District and the Chief Appraiser as the district's attorney regarding all aspects of the litigation, including legal decisions to contest the case, the legal theories of the defense, and application of dealers' heavy equipment inventory statute in connection with the property. Your Honor, what this is about is the plaintiff's attempt to seat a lay witness and ask the lay witness to explain legal positions.
Okay, but was he produced as a corporate representative
It was produced as a corporate representative, Your Honor.
to testify on those matters?
Well, not specifically. I mean, we saw the notice of deposition there, but again, he did testify on many of these matters. But when it comes to how a case was conducted or what explaining legal theories, that's a matter of attorney-client communication. Not saying it's not discoverable in the proper context. It may well be. But when you see the lay witness, we'll go through these here shortly, Your Honor, if I'm not allowed to do so. What these questions are is explain the district's legal position, not what facts are. Yes, the factual basis of contentions are discoverable. If your contention was my vehicle had the right of way, a fact is, was the light green? You can certainly ask a witness that. But again, if you allow to get into these specific questions, Your Honor, and explain the background of the case, I think you find what these questions are designed to do is trip a lay witness up in explaining legal positions, not asking for factual disclosure or even particularly contentions.
Okay, let me let Mr. Moore speak to that and whatever objection he had to the affidavits.
I'm sorry, Your Honor, you kind of cut in and out there. I didn't.
You had wanted to say something to the affidavits? And
Yes, Your Honor. Yeah, I mean, I understand what the affidavits say, and Mr. Swinney's reading of them does not transform them into credible evidence. Again, their contention is all legal contentions are somehow only the purview of the attorney. And if that's true, then again, there can be no discovery as to the legal contentions and the factual basis for those contentions. Or alternatively, as I mentioned earlier, and which is supported by the appropriate case law, Mr. Swinney then becomes a fact witness. We are entitled to ask questions about legal contentions. Their contention.
okay, I'm going to order is that the notice of deposition be redone. JW needs to specifically set out what topics it wants contention answers on. And then Frio Appraisal District needs to designate someone, whether it's Mr. Gonzalez, whether it's an attorney, whether it's an actor that they hire who it's up to
Yes, Your Honor.
on things. And they have to, I mean, the JW is entitled to take a deposition about contention issues.
And Your Honor, we are happy to renotice the deposition and put specific language related to the contentions. We believe the topics that we noticed on were appropriate for that end. All of those topics went to the contentions. All the questions asked were related to the topics. But we are happy to renotice. We just need some sort of assurance that when we ask those questions about the legal contentions and the factual bases, that we're not going to hit a stone wall of attorney-client privilege means you don't get any of this.
Okay. It may be the most costly way to Frio County to do it, but I think that they have to, I'm certain that they have to produce a witness as a corporate representative to testify as to contention.
We are happy with that, Your Honor.
I had that come up in a subrogation case where the insured had actually been bought out and no longer existed. And I researched it at that time, and I was sure with the conclusion that you still had to produce someone. And it was actually the attorney on the other side that said, we're entitled to this deposition, even if they hire an actor to do it. All right, so I'll let y'all work on the format for that order. Next, we have, I think, Mr. Swinney's motion, and we ask the court reporter, do you need a break before we start that? Are you okay?
I'm good, Your Honor. Thank you.
All right.
And Your Honor, again, we're willing to do an agreed order on this, withdraw our objections, and enter into a protective order on this issue, on this motion.
Okay, and have you all conferred about that?
There was a brief conference yesterday where with Ms. Bachman out of Mr. Swinney's office.
All right, Mr. Swinney, would that be helpful to go to a breakout room and talk about that?
It might be, Your Honor. Mr. Moore was distracted with I'm not saying he's not inappropriately, so I think he was in a settlement conference.
No, yeah, it was a day worth of stuff.
Okay, who all needs to be in that?
Well, on our side, besides myself, Mr. Evans and Mr. Corley are with my office. Ms. Bachman, unfortunately, who conducted the correspondence, could not be here as she's obligated elsewhere today. but I think that I can answer on behalf of the district in that regard.
All right, and Mr. Moore, who on your side, just you or?
Mr. Ryan and Mr. Nansen, probably worth having us in there since Mr. Nansen's handled several other counties.
All right, so that's everyone except
And
Julie.
then, well, Ms. Walker is the I believe, in-house counsel for our client.
Okay. All right, I've just given everyone an invitation to a breakout room. And I'm going to shut down my Acrobat and try and go and respond to some emails while y'all are doing that.
I'll be back in about 5 minutes, Your Honor. Is that okay? You're muted, sir.
Sorry. Are you from the San Antonio area? Been here a long time?
No, I moved here about almost 6 years ago. I worked in
All
the
right.
Valley. Yeah, but I
And
live
then-
outside of San Antonio in the Hill Country.
The reason I did that was when I had the case in Atascosa County where they said, you could hire an actor to do it. The district clerk said, and I thought that they ought to hire Chris Maru. He was the Channel 5 CBS affiliate lead newscaster for about 30 years. And he just got bored and went to law school while he was he got his law degree, and he's a licensed attorney. But people spent decades, watching him as the voice of the news, and he looks good in his suit, and he's got that real deep voice. And I thought,
Yeah,
he would be the guy. I would hate to have to, cross him in front of a jury. I don't know if he'd do it, but okay. It
that's funny. Okay, I'll be back, guys.
wasn't my idea. It was district clerks. It was good.
That was funny. Lori, are you there?
Yes, Judge.
Okay, that wasn't me that spoke up.
It was me. It was
Oh,
me. I
okay.
was just gonna chat with Lori. I'm sorry.
Okay. They heard Gloria over here. That's why. Sorry, Judge.
And I said Lori. Sorry about that.
All right,
No, we have an agreement here.
okay.
May I recite it? With
Yeah, go ahead.
Yeah. Go ahead, sir.
a,
I actually, hold on. Yeah, okay, I'm sorry, I was looking around. Ms. Marcinick is back. Go ahead, sir.
Yes, I'm
on
ready.
J.W. Powers' motion to compel the deposition, the order will simply state the fact that J.W. Power will renotice Frio CAD with specific points for inquiries on contention. Frio CAD does not waive its privileges, but will do its best to produce a witness who can respond to the extent a lay witness can respond. J.W. Power will withdraw its motion for sanctions. With regard to the district's motion to compel the second RFPs, we will simply pass the hearing on that at this time until sometime at the court's availability after April 22nd. Because on April 22nd, J.W. Power will produce the responsive documents it does not claim privilege on and will produce a privilege log on the rest. And the parties will either submit an agreed confidentiality order or to the court by April 22nd, or if they cannot agree, will submit versions for the court's discretion.
Okay, all right, and Mr. Moore, is that?
That's accurate, Your Honor.
Okay, do you need an entry date or not to get this?
The order in. I don't know. What do you think, Kurt?
I think we can probably get it in today. Our schedule next week is really crowded. And so if I don't get a draft to you today, I'm frankly looking at another week. And so I'll do my best to get a draft to you today, or unless you want to get a draft to me.
We will get that taken care of today, Your Honor.
All right, so do we need an entry date or not?
Say that again.
So you need an entry date or not? It sounds like you think you're going to be able to agree on the language.
I think we will be, Your Honor. I'm going to guess I'm not sure what you mean by an entry date.
If you don't agree on the language, do you want to have a deadline that back to get that?
I think we can do that by probably Wednesday of next week. Would that be acceptable?
Okay, and I don't know when we have court for Frio County. So let me ask Ms. Riley.
Oh, okay. I see. I'm sorry, Your Honor. I misunderstood what you were like.
April 26th would be like the next time you would be in Frio County, Judge.
That would be on the
Yes.
confidentiality order, correct?
Yes, and on both the orders for today.
Right. Let me check, but I'm real sure that April 26th is good for us.
And nobody needs to be here on it if you've been able to agree on the reducing this to writing and getting it signed.
Yeah,
Right.
April 26th works for us, Your Honor.
We were scheduled to be in trial in Duval County that week, and that's obviously not going to happen. So I can't imagine I'm not free, but it only takes about 15 touches of my thumb and I'll be there, Your Honor. 26th, you said?
Yes.
Oh, that's April 26th. Okay, that was May. I'm free that day, Your Honor.
Okay. All right, then I'll set this on the 26th for an entry date on these orders. But again, if you've agreed on the format, signed off on them, no one needs to be here.
Thank you very much, Your Honor.
Thank you, Judge. May we be dismissed?
All right. Yes, everyone's excused.
Thank you, Your Honor.
Judge. Have a great day.
See y'all soon.